Hello, everyone. We want to start by thanking you for your time this morning to join us for the June edition of our PEP Police Academy Law Enforcement Training webinar. My name is Chris Cadwell, and as the PEP Pool Coordinator of the Public Entities Pool of Ohio, I want to welcome you to our third law enforcement educational webinar for 2021. As you all know, PEP is a member-focused and operated group self-insurance pool. We serve over 570 public entities, and with this size, the Ohio presence and diverse membership portfolio, PEP is uniquely positioned to be a constant source of innovation in responding to risk with mitigation strategies and resources. During the last 30 years, PEP has remained committed to actively raising the quality of the member experience. For several years now, PEP has been extending its commitment for strengthening and growing member services and improving resources. PEP is a devoted supporter of risk management practices and procedures that reduce both the severity and frequency of loss. Our PEP Police Academy webinars embody this effort and are part of a hand-in-glove approach to creating a collection of PEP member resources and services dedicated to this goal. For example, PEP's Legal Assistant Hotline program can be paired with PEP's Police Academy sample policies to make sure our members have policies that are specifically tailored to their agencies, or to further customize sample policies in meeting today's law enforcement rigorous recommendation and requirements. Our goal in conducting these educational sessions is to provide a learning environment that allows our members to become better informed on a variety of important law enforcement topics and issues through presentations and discussions led by experts. In order to best serve the law enforcement needs of our members, PEP's Police Academy webinars are policy-based with written materials authored by partner attorneys from a national recognized Ohio law firm. The issues addressed are relevant and current to local law enforcement agencies of all types and sizes. And each one is available not only via these live sessions, but members can also access them on demand through the PEP website. Inherently, law enforcement agencies constantly face pressing and evolving law enforcement issues that need proper attention and action, whether it's a new requirement that involves implementing or revising policies and procedures, or legal situations involving unfamiliar or prevailing court rulings. To help members address these issues, our educational sessions are intentionally designed and developed by attorneys from the law firm Baker, Dublicar, Beck, Wiley, and Matthews. This partner firm has over 20 years representing political subdivisions in police liability defense litigation and carries with it significant experience representing political subdivisions throughout Ohio. As we move through 2021, you will find that our lineup of subjects and policies dedicated to this program are designed to connect critical challenges and themes confronting law enforcement in their role in ensuring public safety in our communities. Today's webinar, the third in our six-part educational series scheduled for this year, will take a closer look at excited delirium syndrome, the sudden death of individuals who are combative and in a highly agitated state. Today's panel will focus on this medical condition as a life-threatening emergency that often presents itself as a law enforcement issue. One requiring a coordinated approach between responding officers and EMS, which individuals need to intervene, contain the patient, and administer proper medical attention. Failure to recognize and secure treatment for a suspect with excited delirium syndrome may result in a finding that law enforcement was deliberately indifferent to the suspect's medical needs. Accordingly, it is imperative that law enforcement coordinate with EMS to effectively treat an individual showing signs of excited delirium syndrome. Once again, leading the discussion, we are privileged to have partners attorney Gregory Beck and attorney Mel Lute Jr. to share their professional insight and experience in litigation pertaining to law enforcement matters. Mr. Beck handles business transactions and civil litigation with a special emphasis in the area of police liability and civil rights litigation for cities, townships, employers, and political subdivisions, while Mr. Lute's extensive experience representing political subdivision, police officers, and law enforcement agencies has developed his comprehensive understanding of the complex constitutional issues facing modern litigants and he is well versed in those constitutional law questions that surface when defending public entities. Bringing such a wealth of experience in this area, we are privileged to have our panel take us through the condition known as excited delirium syndrome, application of related amendments to the United States Constitution, the importance of assessment tools to help officers identify the possibility of excited delirium syndrome, and the need for developing protocols for officers and EMS safety. Before we get started, there are a few housekeeping matters to briefly go over. First, we'll be running a live Q&A at the end of the webinar, so we have enabled our chat feature. Access to the chat is located on the bottom of your screen, so if you have any questions during the presentation, feel free to drop them into this feature and we'll address them during the live session. Also, at the conclusion of the webinar, an evaluation form will automatically pop up on your browser as soon as the webinar ends. Please take a moment to share your thoughts on the presentation so that we may continue to provide the most meaningful experience for our members. If you missed something, don't worry, we'll be providing access to the on-demand recording as soon as it is available. With that, we can go ahead and get started. Greg and Mel, the virtual floor is yours.
Thank you, Chris. I appreciate your comments. Good morning, everyone. It's a pleasure to be with you again. Mel and I really look forward to the time when actually we can have a live seminar and actually meet you in person and talk in person, interact with you. But I think this medium that we're using is certainly appropriate for the times that we're in. As Chris mentioned, in our previous two sessions, we first began in February with the discussion of the Fourth Amendment. And the Fourth Amendment, as you know, is sort of the bedrock of what police officers do. And so it's very important that we somewhat revisit that whenever we get the chance, because there is no such thing as, overtraining on the fact of the Fourth Amendment and how the 14th Amendment, they both sort of intersect in police encounters. Then in April, we began our first session on use of force, and we tried to set the groundwork for another session that will probably occur in October, because by that time we'll have better understanding of the federal legislation and how things are progressing at that point. And we want to, at that time, also introduce some additional information through excited delirium, only because we work closely with a physician out in San Diego named Gary Vilke, and he has lectured all over the country and is an author and scholar on the issue of excited delirium, and he'll share some interesting aspects of his training at that time. But we felt that it would be important now to just sort of give you the groundwork and sort of give you a homework project, which I'll get to in a minute. But first of all, as we talked about in April, there is a big move in police to this notion of de-escalation. And typically when we would talk about de-escalation, it would always be in a sort of a confined process. But when we address issues regarding excited delirium, I believe the de-escalation is important. And I mentioned here on this slide the concept of the ADA, the Americans with Disabilities Act. We're starting to see some effort by plaintiffs' lawyers when their clients also suffer from a disability, and that can certainly occur. And so we need to be mindful that there are some people that we might run into that have some sort of incapacity that's related to a disability, and their failure to cooperate with us may not be because they're being defiant, but simply because they don't understand. So we have to be aware of these issues with the Americans with Disabilities Act, but what we really want to focus on today is how we address this notion of excited delirium. So what I wanted to talk to you first about is describe the problem and how it fits into the context of the 4th and 14th Amendment. And then Mel will get into more gritty details about this syndrome known as excited delirium. And I use the term syndrome very specifically, and that's because the American Medical Association and the American Psychological Association have not recognized excited delirium as an actual diagnosis. In other words, if you went to a psychologist and their Bible is the DSM-5, they can't find excited delirium in that book. But most emergency room physicians recognize it, their associations recognize it, and most emergency medical services recognize it. So it is a real syndrome, it is a real issue. And we call it a syndrome because it's a constellation of issues that all present at once that come from different angles, but it sort of has the same presentation. So this actually, what you see here on the screen is 2 paragraphs that I actually pulled from an EMS sort of guideline. And it talks about the stereotypical case of the middle-aged man who is somehow running around naked, becoming a real problem. And that's and Mel and I have had several cases like that where the person, the 911 call comes in and it is someone that's out of control, running around in the neighborhood, usually in the middle of the night, and they're essentially disturbing the peace at that point. They might even be a trespasser, but of course the nature and magnitude of the crime is very minimal, but the problem that they're presenting is significant, because if they're presenting these symptoms of excited delirium, it is really it's a medical emergency as opposed to sort of a criminal investigation. And as this notion really says here, some patients may fall victim to the phenomenon known as sudden unexpected in-custody death if excited delirium goes unrecognized and untreated. And this part right here, unrecognized and untreated, is critical for us to understand. We need to understand what this is, what it looks like, and what can happen. When Dr. Vilke talks with us in the fall, he'll talk to you about excited delirium as it presents in a couple of different formats. And what he's going to tell you about is that in general, it will appear to you in 3 stages. And from our perspective, we want to try to get involved and get medical help in the first 2 stages. The first stage is where the person is somewhat bizarre acting and they may be nonsensical, but they're not aggressive, they're not overacting. And, you know, I think we have somewhat of a textbook model when we look at the George Floyd tapes. We've all seen those tapes and we all seem to focus on what happened when, you know, Officer Chauvin has got his knee on his neck. But really, if you look at the front end of that tape, that is really what we would describe as first stage excited delirium. This person seems disoriented. They don't seem well. They are coherent, but they're not right. You can tell there's not something right. And that's the first stage. If you recognize these symptoms, you recognize what they may be, you know, nonsensical speech, constant motion, paranoia, the superhuman strength and the decreased pain sensation doesn't really manifest at first. But imagine what would have happened if instead of allowing this to unfold the way it did, someone said, we need to get a squad, let's set him down. And they started talking to him and saying things like, sir, we want to help you, kind of give me your name. We're going to call a squad. We're going to get EMS here. We're worried about you. And then the squad would have come, they would have taken over from there. If he then evolved into what we call the second stage, which became a little bit aggressive, a little bit resistant, they would have been able to give him a sedative. They would have been able to sedate him. They would have been able to whisk him away. And see, this is where EMS really comes into the fray here, because the problem that we've encountered for the last 10 or so years when seeing these cases is that EMS is not called until the person enters stage 2 or even stage 3. Stage 3 is when they're extremely combative. They show the superhuman strength. They're out of control. It ends up in a wrestling match. The person ends up on the ground. They're multiply tased, and then they just die suddenly. And they die because their whole system has become overloaded and is fried. And Mel will get into a little bit of the specifics of what's happening. But so a person would evolve from stage 1 with sort of disorientation. You can tell there's a problem. Stage 2, they become resistant. They become difficult to handle. Stage 3, they are now in full bore excited delirium. They have metabolic acidosis, which means their chemical imbalance within their blood has changed, so that the fact that all of their organs become literally overtaxed to the point that they fail. Dr. Vilke describes excited delirium in stage 3 as if you went and started your car, left it in park, and then put the accelerator to the floor until the engine literally melted. That's what happens. When you look at what happens to someone on an autopsy and what their condition was, you see that they went into heart failure, they had oxygen loss to the brain, so the brain died. They had a core body temperature of over 105, 106 degrees. Now imagine this. I don't know if you can appreciate the significance of this. We've had cases where when they reached the ER after death, half an hour after death, core body temperature was still 105 degrees. Well, most of us will die just as a result of that type of situation. But what happens is that every switch in the body that normally controls our behavior when we get overtaxed remains open. And so a person will literally resist, fight, scream, run until their body completely fails. And this has to do with a chemical imbalance that's created by this whole syndrome that can be caused by a whole lot of situations. So you ask yourself, what can happen if we don't recognize this? Well, what can happen is right here, the in custody death. And so we have to sort of rethink our mindset about how we must approach these things. Because if we look at every one of these cases, and again, we can look at the Floyd case. I mean, you think about the probable cause for his detention was based upon him using counterfeit bills. But that wasn't a crime of violence. He wasn't causing any real disturbance to the peace. Every case that Mel and I have handled, and we've had a bunch of them, involve minor misdemeanor activities, trespassing, maybe disturbing the peace. We had one with a little minor assault. Every one of those cases were minimal criminal activity. The core issue was that it was a medical emergency. And so we look at these causes, and they come from a variety of causes. It can become from illicit intoxication of all kinds of different types of drugs. The metabolic acidosis is this, which is the description of what really happens when the systems continue to burn out. The hyperpyrexia is this whole notion that my body temperature elevates to the point that it would be deadly if it had come from an infection. And so the body is burning up, all the systems are being taxed beyond belief. And some of this can also be caused by some psychiatric illness because, again, so much of our activity is based on brain chemistry. And all of this brain chemistry is being scrambled by what's happening to them emotionally, what's happening to them physically, what they may have taken inside. And when all of these things align, it becomes sort of the perfect storm for someone to have this sort of difficult situation. And so when we think about it, this is your homework. If you have not done it, and you probably have, but if you have not done it, the first thing you need to do is you need to contact your EMS chief or your fire chief who's in charge of your EMS, and you need to set out a coordinated plan together. In other words, whenever there's an officer in the field, and actually it's just start at dispatch, it's to start at the 911 call. If dispatch gets enough information that suggests that this might be an excited delirium or an aggressive, excited, agitated person where excited delirium is the issue, you need to have EMS there with the police. Too many times we leave the police officers as the first responders and they're not capable of really diagnosing, but they can see and they're great observers. You all are. You will observe these signs. And what you really want to do is when you give assurance to the person and you try to say you want to help them and you have EMS staged, if it looks like they're going to resist or have a problem, you want to have enough officers there to be able to get this person under control, and then you're going to give them the sedative. And the one that they're using most is ketamine. Most EMS squads have that on board. It's a very fast acting sedative. It'll take the person down completely, and then they can transport them to the ER. And what Dr. Vilke will tell you is if I have a person in stage 1 or stage 2, I can probably save their life. However, if they're at stage 3, they're probably in a state where their whole body starts to fall apart and they've started losing major organs and they could literally die even in the ER. And he'll tell you situations where, he's had them in there and he can't save them. He's looked at some of our cases and said, if I would have been standing right there by the time the police arrived and he became combative, I don't think I could have saved his life. So this is a very serious thing. So the first thing you have to do is adopt a coordinated approach. You have to recognize this as a medical emergency, and it needs to be deemed as a medical crisis. And imagine what can happen now, because we're documenting things through body cams and dash cams and our reports. If the dialogue is, we're here to help you, please let us help you, let's call EMS, I'm worried about this person, we think he is an EXD, we want to get him help, and you're bypassing the whole criminal side of this. Now your approach is exactly where it needs to be in terms of the Fourth Amendment. And why? Because the Fourth Amendment is, of course, the mechanism by which we are protected from unlawful searches and seizures. And as we know now from the Torres case that came out several months ago, the Supreme Court basically said that any seizure, any detention, stop me on the street, ask me a question. If you're doing that as a police officer to control my movement at that moment, you have literally seized me under the Fourth Amendment. And so that seizure has to be reasonable. It has to be based upon reasonable suspicion or probable cause, or in an effort to try to help you. Now, most of these situations that you're going to encounter as a police officer where you deal with these type of people, you're going to have reasonable suspicion at a minimum, or probably probable cause to stop them, to try to help them. So your pathway is clear. But the difference under the Fourth Amendment here is if what you're trying to do is seize them for purposes of getting them help, as opposed to seizing them to take them to jail or to book them or to issue them some sort of citation, it is like a night and day difference. And the difference here is just switching our mindset. So we need to document it, we need to talk about it, and we need to get EMS staged. And this is going to take a coordinated effort. Now, the thing is, we have to understand how the Fourth Amendment dovetails with the 14th Amendment. The Fourth Amendment, it regulates reasonable searches and seizures. The 14th Amendment says that the minute I have now seized you, I own you. In other words, if I now detain you, I recognize you have symptoms that might be lethal to you if I do nothing, and then I don't take action to get you medical help, I could be claimed to be deliberately indifferent, because the 14th Amendment says that under the Due Process Clause, I have to protect you from things for which you can't protect yourself. Because I've restrained your liberty, you can't go get medical help, so I have to get it for you. And so that's how the 14th Amendment then dovetails with the Fourth Amendment. So when we look at this we step back and say, how do we look at these things strategically? If our officers are encountering anybody with these type of symptoms, and you've all heard about these now for the last 10 years, now we just have to have a different strategic de-escalation approach. It has to be, this is a medical emergency now. As Mel likes to say, the first thing in your mind should be, you're going to leave in an ambulance, not in a squad, not in a cruiser. That's the idea. And the minute our officers start thinking that way, it changes everything. It changes their approach. It changes how they talk. It changes what they do. And if what you're really trying to do is not restrain the purpose for purpose of custody, but restrain them and control them for purposes of giving them sedated or getting them to the hospital, you've now operated completely within the protection of the Fourth Amendment. And that's important, of course, because of the issue of qualified immunity. We all know that qualified immunity is under serious attack right now. And qualified immunity, of course, is part of the common law. Common law, of course, is law created by the courts versus statutory law, like the constitutional law or laws regulated by statute. So the common law of qualified immunity, which was established first in Harlow versus Fitzgerald, is still viable and still makes sense, because it basically says that, if the officer's conduct was objectively reasonable in the context of the Fourth Amendment, then immunity applies. And, I don't know how your conduct could be anything but reasonable if your whole approach is, I want to help you, let me get you a squad here, let me see if I can help, what do I need to do? I don't want to arrest you, I just want to get you to the emergency room. And all of those things, I know it sounds easy for me to say, but you can imagine the difference in this kind of situation if that's recorded, it's written down, and you've taken the logical steps to get these people help. And so that changes everything. And so many times the officers have those intentions, but they're not vocalizing it. And it ends up in a brawl. And these people then end up dying in custody, either because they're just completely fried or because of something else that happens. And you know how this works. So in the context of this whole discussion, I've sort of told you what your homework is. You need to think about how you can coordinate with EMS. And I believe it starts at dispatch. Maybe there's a different code. Maybe there's a special code for what dispatch believes it might be an excited delirium, or someone that's having a mental capacity or emotional capacity problem. And then from there, everything starts with dispatching, police and EMS at the same time, a coordinated effort, get them staged. And when I say staged, we've had people staged where they're 2 blocks away. If I had my druthers, they would be staged like right there. I know you got risk issues, you got danger issues. I know you have to coordinate and protect, but the closer they are, the faster they are, they can get there, the better off you are. So really what I want to leave you with as Mel begins his discussion is that there needs to just be a very practical approach. The practical approach is to coordinate with EMS. The practical approach is to change the mindset that this is a medical emergency as opposed to something that's going to be criminal in nature. The legal or constitutional approach is, if you follow the practical approach, you are now protected within the ambit of the Fourth Amendment. Your conduct will be objectively reasonable. You won't be deemed deliberately indifferent under the 14th Amendment, and you will have actually operated in the best way to protect the public. And it would be, many times it's heroic to do these things in this way. We set aside what we think is a crime and we look at what's in the best interest of the person that we're addressing. That is a tremendous thing to do. And then, of course, from a liability standpoint, qualified immunity would pop up to protect the officers. And keep in mind, too, and I'll leave you this final thought, that the big move right now in attacking qualified immunity is probably to hold the entity liable. In other words, right now, your city, your village, your jurisdiction could be held liable under what we call a Manel theory, which is a policy, practice, or custom that in application led to some constitutional violation. But it requires an underlying constitutional violation in the first instance engaged in by the officer. We believe that the legislation is just trying to sort of bypass that issue and create almost strict liability for the entity if there's an underlying constitutional violation. How are you going to get around that? It's through the proper training and through the proper policy. So that's how this all somewhat comes together. So I know I've thrown a lot at you. I'll be available afterwards to talk to you and certainly on the chat here. I'm going to turn everything over to my partner, Mel, who will get into the details about the actual excited delirium syndrome.
Thanks, Greg. I want to pick up with just defining excited delirium in the context of putting a name on it. Now, what name you choose to give to it is up to you, but excited delirium seems to work as a means by which to identify these symptoms that are presented when police officers encounter these subjects. So the term was first coined in 1985, and we have these emergency room physicians around the country, and they're really on the front lines of this excited delirium syndrome because they see it in these emergency rooms. And unfortunately, medical examiners as well see the results of this excited delirium syndrome. And so that's why it was sort of discreetly defined. It has as its cause both substance abuse, mental illness, and in the worst case, and frankly, in most of the cases Greg and I have had, a combination of the two, where you have a person who perhaps is under treatment for psychiatric illness, they've had a mental break, perhaps they're off their medication, and then they're also using substances such as methamphetamine or cocaine, and then that deadly combination contributes to the development of this syndrome. Oftentimes, it can be an unpredictable reaction on the part of the person to cocaine or methamphetamine. Oftentimes, it might be a family member who calls the cops, who says to dispatch, this person is not acting the way they normally do. They've had a psychotic break. They're running through the neighborhood, taking their clothes off, things like that. And so we have both substance abuse and mental illness as a potential. So when you're hearing that dispatch, those are the keys that you're looking for. History of depression, schizophrenia, bipolar disease, psychotic break, off the medications. So those are sort of the buzzwords or the signals that you hear. Now, the other part about it is that you need to be able to recognize the signs and symptoms. And of course, as a law enforcement professional, the idea that you might encounter someone under the influence of alcohol or someone under the influence of drugs is not a huge revelation, right? Most of the time, many times, you're going to encounter that just in the course of your everyday work. But this is different. This is a different thing. This syndrome is outside the realm of that normal signs of impairment. Here, you've got signs of overheating. That is an absolute red flag for this syndrome. You've got a person, perhaps even in a cold weather environment, taking off their clothes as if they're burning up from the inside. They're foaming at the mouth. They're drooling. They have superhuman strength. You may encounter people who have already injured themselves, but they appear impervious to pain. So they may bear signs of scratches or cuts or bleeding where they have put their hand through a window or they've injured themselves, and they seem impervious to it. They're extremely aggressive. They are hyperactive. They have difficulty concentrating on any one thing. They're paranoid. They're looking around. One of the really weird parts of this is a reaction to a reflection. People under this syndrome, if they see their own reflection in a mirror or in a, say, the chrome of a vehicle or in a window, they may lash out at that reflection in a violent way. It's just one of those characteristic behaviors that have been witnessed by a number of officers. And so the fact that you have this hypothermia happening means there is something going on physiologically inside the body of the suspect or subject, and it's happening anyway. It's happening anyway. And so you've got hypothermia, so the temperature is rising. Then you've got blood acidosis. So you've literally got our life-sustaining blood product in the body deteriorating to the point where it cannot do its job of delivering oxygenated blood to the body's organs, okay, into the brain. You also have electrolyte imbalances, which again could be one of the things that leads to this sort of superhuman strength. You know, you've got an adrenaline dump. You've got a breakdown in muscle cells because of the acidosis. Respirations can become very, very labored, especially during any type of prone restraint. So positional asphyxia is always a concern, particularly when you have to go to ground with these people to get them into the position where they can be sedated. The resistance is typically very violent. So the officers have to worry about their own safety. In many instances, including the cases Greg and I have had, you can have multiple taser applications with minimal effect. Even when you get good probe contact, even when you get a good spread, oftentimes these people simply are able to power through essentially the effects of some of the taser deployment. Greg talked about coordinating EMS with your law enforcement response to excited delirium. And we can't say enough about the importance of that, because having those EMS personnel there just reinforces that narrative that you're having a dialogue with the subject, saying to the person, we're here to help you. We're here to help you. Let us help you. And of course, seeing an ambulance stage nearby is just a reinforcement of that. You've got EMS personnel who are trained to administer the sedation. They're also trained to go ahead and administer that immediate life support if necessary, and additional restraint, frankly, if that's needed. Your use of force options in a excited delirium context would include some type of control technique or hold. Pepper spray has not proven to be particularly effective. Impact weapons have not proven to be particularly effective because there is not going to be a predictable or conventional reaction to pain stimuli. They're just not going to feel the pain. So even if you were to perhaps fracture something in the course of deploying an impact weapon, it's not going to have the desired effect. Tasers, again, have not proven to be particularly definitive. They can be a pathway to allow you access to touch the person and perhaps put enough bodies on contact to get them under control so that they can be sedated and treated. Restraint options, you have to be very careful. Prone restraint is not advised. Putting the person on their side, protecting that airway, monitoring their vital signs if you can as soon as possible, very, very important. I can tell you that the cases we've had very, very experienced police officers engage excited delirium suspects in a struggle to bring them under control, to handcuff them. And they are shocked, absolutely dumbfounded by the speed with which a excited delirium subject can go from fighting like mad with multiple officers, superhuman strength, to absolute flatline, unresponsive, totally and completely inert. And it can happen in a heartbeat, and it does. And that's why we want to have those EMS personnel staged. We want to have them ready so that they can get that person in an ambulance, get them transported as soon as possible. And there's no doubt about the fact that this is a life-threatening medical emergency. And making that mental adjustment after the police officer encounters the suspect or the subject and says, okay, maybe there is a low-level crime in progress. Maybe it's a trespass. Maybe it's a low priority type of shoplifting. Maybe it's a menacing. No one's been hurt, but the person's got to be dealt with. You can deal with those criminal elements of the encounter later. The fact is, if you're seeing those signs and symptoms, the hypothermia, the superhuman strength, and you've got details from dispatch or your interviews with personnel on scene that tell you this is a person with psychotic break, this is a person with psychiatric history, they're off their meds, et cetera, you shift the mindset. You shift it from dealing with that trespass or that menacing to dealing with a medical emergency, and you say to yourself, I can't wait this person out. I cannot wait this person out because there are things happening in that person's body that are progressing, and they will progress and continue to the point where that person will lose their life. And we need to get a hold of them, get control, get them treated, get them to a medical facility. And the fact is, even if you do all of those things, the research suggests that 2/3 of these excited delirium persons may die anyway. But we have to do what we can, and you should try to do what you can to get that treatment as soon as possible, because medical science believes, and we'll talk more about this in the October presentation, but there may be a subset of excited delirium subjects that can survive this with appropriate therapeutic intervention. It's difficult to fully define the contours of this syndrome because many of the excited delirium cases come to us through post-mortem studies. And so we don't have there isn't a wealth of information out there from people who have survived this, frankly. But some things have come to light which are scientifically reliable, and that is the profile of an excited delirium subject. 95% of these cases involve male subjects with a mean age of 36. They are hyper-aggressive, they have bizarre behavior, they're impervious to pain, they're combative, they're hypothermic, they're tachycardic. They have these characteristics. And so again, going back to the beginning, to that dispatch, is it a male? Do we have an approximate age on this male? Do we know anything about this male's history, drug use, psychiatric care, etc.? We start to formulate that profile, and then we take that dispatch information combined with what we see on scene and what very well may be seen later in your body-worn camera footage. And it's going to get to that question that Greg and I have heard many times by lawyers representing the family of the decedent who has died in police custody. Officer, didn't you recognize the signs of excited delirium? Did you see this? Did you see that? Did you hear this on the radio? Did you hear that? If you understood the signs and symptoms, why didn't you stage EMS personnel? Why did you engage this person in a prolonged struggle and accelerate that acidosis? Things like that. And with these body-worn cameras now, the trier of fact is going to be in a position of seeing those signs and symptoms as well, right? So we want to understand the pathophysiology of excited delirium and how it works. And this is still in progress. You've got some of the brightest minds in medicine that are dealing with this, trying to understand it, and it's not easy. And so for you, for a law enforcement personnel, for a chief, for an executive in a police organization, to be responsible for, vetting this that's very difficult too. So we understand that, but we just want to give you as many tools as we can out here on the cutting edge of this particular syndrome. Now, what it looks like from the studies of brain slides of deceased subjects is that prolonged cocaine abuse tends to reduce the number of dopamine transporters within the brain. And so what happens is these dopamine receptors that are responsible for thermal regulation, your internal thermostat, if you don't have as many sensors, if you don't have as many dopamine receptors because you've essentially burned them up through repeated drug abuse, then the body does not have the ability to regulate itself. And once this chain reaction begins, this neurotransmission just goes haywire, and the hypothermia just starts and it doesn't stop. And the central dopamine hypothesis also has a link to psychiatric etiologies as well. So you do have those cases where you've got people without thermal control because of their prolonged drug use, and you have this psychiatric component which is driving it. This is an acute life-threatening medical condition, no question about it. The priorities, if you will, are to recognize it, contain the subject, stage EMS, get them ready, and only when you have sufficient personnel to subdue the person quickly should you do so, if you can, so that you've marshaled all of your forces before you close on the subject. Because once that fight starts, it's going to simply accelerate. So you've already got an engine that is hot, and now you're going to just press down on the gas for the duration of that struggle. And so if you can reduce the time of the physical struggle by simply adding bodies, you need to do that. Also keeping in mind, of course, positional asphyxia and some of those other concerns. If you can do it, if you can swarm that subject and quickly get them into a controlled position, the recommendation seems to be among medical personnel that the use of chemical sedation at the site may arrest the progress of this inevitable hypothermia and this destructive internal pathophysiology, okay? So a lot of EMS departments have begun carrying ketamine or Versed. Either one are basically sedatives that can be used by injection right at the site, and they have the effect of simply shutting down that process of the person just continuing to hyperventilate, continuing to energize. This is an aggressive chemical sedation, and it can be used to help the person get them into a position where they can be transported. That physical struggle at the very point of handcuffing is really where the action is in these cases. And that's why if you can shorten that time, it's very, very important. We understand that EMS safety is very important, and that a lot of EMS units, a lot of departments have a policy. They're not going to let their EMS people get anywhere close to a scene until it is under control and it is safe. And that's understood. But again, with proper EMS coordination with the police department, and as Greg suggested, maybe even having a subset of a certain code that is assigned to excited delirium that will tell the EMS people, we've got a ketamine situation likely to erupt here. We need to get this ready. We need to stage close by. We need to be ready to close on this subject very quickly once we get the green light from the officers on scene that the scene is secure. That's very, very important. Ketamine, it just basically distorts the user's perception of sights and sounds and creates that detachment or dissociation from the environment and calms the situation down. So far, it has shown excellent results, and that's why it's getting put in ambulances all over the country. So once you have a person secured, they need to go immediately to the hospital. And oftentimes, EMS personnel or police on scene can aid the subject by immediately trying to cool the body, putting ice on the body, making sure that clothing is not restrictive. If the person has a coat on, getting the coat off, cooling the person down to get them to where they need to be. Now, despite all your efforts and everything that you do, it's not a guarantee that you're going to prevent excited delirium deaths, because there are still many, many questions that need to be answered by medical science to really get a handle on this. But if you follow these steps that we've recommended, you will go a long way toward giving that person a fighting chance. And that's the most important part of this, recognizing it as a medical event and trying to prevent this in custody death that can lead to litigation. And I would suggest this also, that anytime you're engaging in any type of training in the use of force or de-escalation, it is a great time to revisit this excited delirium subject and talk about how you might incorporate the recognition and identification of excited delirium into your use of force and into your de-escalation protocols. And with that, I'll open it up for questions and answer any questions that anybody might have. Greg and I can certainly do that.
All right, I don't think we have any questions. Thank you, gentlemen. It was a wonderful topic, and I know I learned so much. So as a reminder to everybody, this session will be recorded, and we will email this out along with the slides. You can find this on the PEP website behind the member login. Should you need a login, please email pep@pepohio.org, and we will get you set up with one. Thank you, everybody, for your time, and I hope everybody has a great day.
Thank you.
Thanks a lot. See you.